स्टडी IQ IAS, अब तैयारी हुई अफोर्डेबल।
Welcome to StudyIQ's initiative, the podcast. I am your host, Dipansh Moorjani. So tighten your belts, it is time for the podcast of the day. In the last episode, we were discussing fundamental rights, and with the guidance of Sir, we covered all provisions of our constitution till cultural and educational rights. All our new listeners can listen to our previous episodes to understand the provisions mentioned in our constitution under fundamental rights. In this episode, we are going to discuss right to constitutional remedies, and there is nothing wrong in saying it is one of the most important topics for any UPSC aspirant. Sir, can you tell us if our fundamental rights are harmed or breached either by state or by any individual, then what can we do? Does our constitution provides some provisions for this situation?
Yes, there is a law in India that provides that a person can petition the Supreme Court if they feel their fundamental rights are being abused and they seek those rights to be safeguarded. In the Supreme Court, this right is protected by Article 32, and in the High Court, it is protected by Article 226. It is referred to as a right to constitutional remedies. Additionally, local courts have the authority to grant rights extensions. However, there is one activity covered by martial law, the court martial, that is immune from this privilege. Right to constitutional remedies. The main objective of Article 32 is to provide a guaranteed, effective and cost-effective remedy for the protection of fundamental rights. The Supreme Court has original but not exclusive jurisdiction over implementation of fundamental rights. Article 32 establishes the Supreme Court as the protector and the ensurer of fundamental rights. Furthermore, the apex court has original jurisdiction over the power of issuing writs. In simple words, if the fundamental rights of an individual are being violated, that person can contact Supreme Court directly for its remedy.
Sir, Dr. BR Ambedkar used to call right to constitutional remedies as the heart and soul of fundamental rights. So we are curious to know, why did Dr. Ambedkar call this right as the heart and soul of fundamental rights? And what are the provisions which make Supreme Court and High Courts a protector of this fundamental rights?
Dr. BR Ambedkar stated during the Constituent Assembly debates in December 1948 that the rights conferred on the Supreme Court by this article could not be taken away unless the Constitution was amended, and thus it was one of the greatest safeguards that can be provided for the individual's safety and security of their fundamental rights. Others in the drafting committee also said that since it gives a person the right to approach the Supreme Court as a remedy if fundamental rights are violated, it is a right fundamental to all the fundamental rights guaranteed under the Constitution. To understand this, we need to understand about writs. A concept of writ. A writ can be defined as a written order which is issued by a court of higher authority. It is granted to a lower level court or to an individual in the event of a breach of citizens' basic rights. A writ petition is generally filed in case of violation of fundamental rights or injustice served to any individual or aggrieved.
Sir, students often get confused while studying different kinds of writs. So can you explain in simple words the different kinds of writs that is mentioned in our constitution?
Article 32 and Article 226 of the Indian Constitution provide two separate but parallel provisions regarding the writ jurisdiction with the Supreme Court and High Court respectively. There are 5 types of writ petitions. First, writ of habeas corpus. Second, writ of mandamus. Third, writ of prohibition. Fourth, writ of certiorari. And fifth, writ of quo warranto. Now, in this series, we will first look at first writ, which is writ of habeas corpus. It is considered the most crucial writ for personal liberty. Habeas corpus literally means let us have the body. A person can move to the court for the issue of this writ when get arrested. This writ gives power to court when your arrest is illegal, and in this case, court will decide that your detention arrest is illegal through any authority of police or individual. Habeas corpus assures that those who have been detained are not held in unjustified custody. The second writ is writ of mandamus. Mandamus is a Latin origin word and it means we command. It is an order from a superior court to a lower law authority or public authority to perform an act which falls within its duty. It is issued to secure the performance of public duties as well as to enforce private rights held by the public authorities. The next writ is writ of prohibition. In the writ of mandamus, it can be basically summed up as a writ issued to a public official to do a duty that he has failed to do so far. The next writ is writ of prohibition. This writ means to forbid or to deny, and it is popularly known as a stay order. This writ is issued in case when a lower court or a body makes effort to transgress the limits of powers vested in it. The Supreme Court issues such a writ to forbid a lower court or tribunal to perform an act that is outside its jurisdiction. The next writ is writ of certiorari. Certiorari means to be certified. The Supreme Court holds the authority to issue the writ of certiorari to a lower court or tribunal to transfer the matter of concern to it or some other superior authority of critical consideration. The Supreme Court issues a writ of certiorari to overturn an order that has already been made by a lower court.
Sir, please explain to us the difference between the writ of prohibition and the writ of certiorari.
While the writ of prohibition is available during the pendency of proceedings or during the proceedings, the writ of certiorari can be restored to only after the order or the decision has been announced. Both the writs are issued against legal bodies. Now we will understand the writ of quo warranto. The quo warranto in letter means by what authority. It is issued in order to investigate the legality of a claim by a person or an individual that is not entitled to act in a public office. The quo warranto letter is a form of judicial control that examines the actions of the administrative agency that has hired the person.
Sir, while studying right to constitutional remedies, a UPSC aspirant has to go through all the important judgments which are basically interpretations of Supreme Court. So, can you explain to us in simple words as to what Supreme Court says when it comes to protection of citizens' fundamental rights under right to constitutional remedies?
There are some important judgments related to Article 32. And Supreme Court have time and again been inconsistent with its position regarding Article 32. Why we are saying this? It is because in some cases, Supreme Court have asked the petitioner to go to High Court directly rather than come to Supreme Court directly. In the case of journalist Siddiqui Kappan case, the court asked why the petitioners could not go to High Court and waits response from the centre and the UP government. Nagpur-based man defamatory case, the same bench directed him to approach High Court first. While in Arnab Goswami case, the court had said that the right to approach the Supreme Court under Article 32 is itself a fundamental right. It is also observed that there is no doubt that if a citizen of India is deterred in any case for approaching this court, that means Supreme Court, in exercising of his right under Article 32, it would amount to a serious and direct interference in the administration of justice in the country. So we can understand that Supreme Court have time and again said that you can approach the High Court first and then you can come to the Supreme Court later. However, in some cases, Supreme Court have stated that you can approach the Supreme Court directly, and approaching the Supreme Court directly is your fundamental right.
Sir, as you had mentioned earlier that the Supreme Court and the High Court can protect citizens' fundamental rights. Both Supreme Court and High Court have the power to issue writs, but can you elucidate on the differences and similarities between Article 32 and Article 226?
There are few similarities between Article 32 and Article 226. Both Article 32 and 226 is invoked for the enforcement of fundamental rights. Both the Supreme Court and High Court has the power to issue writs. However, there are few differences between Article 32 and Article 226. Article 32 is invoked for the enforcement of fundamental rights only, whereas Article 226 is invoked not only for enforcement of fundamental right. Hence, we can say that the power of High Court under Article 226 is wider than the power of Supreme Court under Article 32. Power to issue writs under Article 32 is mandatory for Supreme Court, whereas High Court has discretionary powers to issue writs under Article 226. Hence, we can say that the constitutional remedies provided to the citizens are the powerful orders with immediate effect, and the writs are mostly invoked against the state and are issued when PILs are filed. The writ jurisdiction which are conferred by the Constitution though have prerogative powers and are discretionary in nature, and yet they are unbounded in its limits. The discretion, however, is exercised on legal principles.
Sir, after your explanations, we can say that fundamental rights provided by our Constitution remain protected in every situation through judiciary. Dear listeners, it is time to wrap up this episode of the podcast. In the next episode, we will be back with another issue of fundamental rights. Till then, keep studying and stay connected with StudyIQ. You can listen to StudyIQ presents the podcast on various audio streaming platforms such as Spotify, Hubhopper, Google Podcast, Apple Podcast, Kuku FM, etc. Links are pinned in the comment section below. Thank you.